Hello, this is Dr. Prasad Pudilam with my YouTube channel, My Intuition 4865. So, this is the class series on BRMK557, that is Research Methodology and Intellectual Property Rights. I'm on to Module 5. Okay, with this subject code BRMK557, I made the video for Module 3, Module 4, and this is Module 5. Module 1 and Module 2, they are exactly the same as previous years or previous schemes syllabus. That is 21 RMI 47 that you can find it in my YouTube channel playlist of research methodology and IPR. Okay, so few changes in Module 3, Module 4 and Module 5 which I included and made a video. I didn't elaborate whatever the changes, more changes that they made in that one, including that this particular videos are prepared. Okay, so my YouTube channel, it is My Intuition 4865. Please do subscribe and support. I have handling classes from first semester, first year, second year, third year, and even when you go to fourth year, subject some of the general subjects which are common to all that you can find in my YouTube channel. Okay, moving on to the syllabus. Syllabus is mentioned here that you can go through the syllabus of 2022 scheme of Visheshwara Technological University. Okay, the topic which I chosen for this means I chosen all these topics from that, and I am preparing the question, and its answer is also given. Answer scheme is given, and I am giving a little bit explanation of the answer scheme. Okay, so moving on to question 1 of module 5, which is connected to the course outcome 5, which is mentioned in the syllabus. Level of question is RBT level is 2. So explain the eligibility criteria for registering an industry design in India. Okay, so answer scheme starts like new or digital, new or original design. Okay, so for a design to be protected, it needs to be new and not something that has been seen or used before by the public. So if a design is already known, it cannot be considered original. For example, when you prepare create a new style for a coffee cup, which means that you have never seen it before, with a unique handle shape and pattern for that coffee cup. So if no one has made or shown this design before, it is considered as a new or original. But if the same design has already been used by another company, it would not be eligible as a new design. Second point, that is it applies to the articles. The design has to be applied to a real object, or it should be applied to an article like a product, like say a t-shirt product, or things you can touch. The design, it is not just an idea or a drawing. It has to be used on something physical like the clothes or on furnitures or on electronics, say mobile phones. So for example, if a unique pattern for a t-shirt, then your design is applied to the t-shirt which is a physical object. So if the design only exists as a drawing on paper, it is not used as a actual t-shirt or product. It should count as a design for an article. Then comes the aesthetic aspect. The design should be about how something looks, its shape, the decoration, the pattern. It should not about how the product works, but rather how it makes the product very attractive or appealing to the eye. For example, if you take a chair has a special curved backrest and a very beautiful pattern which is carved into the wood. So the design, it doesn't make the chair more functional, but it makes the chair look more stylish and visually appealing. So this is aesthetic aspect of the design. Fourth point, non-functional. The design should not be based only on how the product works. If the way something looks is purely make it function better, then it is not considered a design. Design focus on appearances and not function. For example, a water bottle, it may have a special curved shape to fit better in our hand. But if that shape is purely to make it easier to grip a functional purpose, then it may not count as a design. However, if the bottle has a unique artistic pattern or decorations which don't affect how it works, those would count as a non-functional design element. I'll repeat because of the sound of the phone. You might have not heard. So I'll repeat. An example was given that water bottle. It is made a special shape. The curved shape is made, but it is only to get an easier grip. It has got a functional purpose. Okay, if that functional purpose is not there, then that cannot be treated. Moving to the next topic, next question. Describe the procedure for registering an industrial design in India. So the topics which I used to cover these are enforcement of design rights, protection team, procedure for registration in industrial designs, then prior art search, applications, duration, cancellation, and the application forms. These terms already class videos made. So a different one, it's already there in my YouTube channel playlist. You can see a different question is framed here. So that is describing the procedure for registering an industrial design in India. Okay, so answer. Start with filing the application. For example, this is the first step to protect our design, that is filing an application with an appropriate government office. We need to provide the detailed information about the design, and it include drawings or images, and it show how the design looks. So this helps others to understand exactly what we are trying to protect. For example, if we are creating a new furniture design with a unique shape for the chair, or we have to submit an application which shows the pictures of the chair from different angles and explaining what makes our design different from other chair designs. Second point, that is examination. After our filing the application, the government will examine our design. So they will check to see if the design it is meeting the legal rules, such as it is a new one, it has got originality. They will check if the design is only for how the product looks, not how it works, and if it applies to a real product. For example, the same chair design, the examiner, he may check whether our chair looks different from others chairs, and make it sure that it's just a functional feature, like a new type of a chair, new type of chair leg, which helps to balance it better, like that. Third point, that is publication. Once design is approved, then it should get published. They will publish it in a government gazette or government publication. Usually we call it as official gazette. Okay, so this official gazette, it lets the public to know that our design is officially registered and it needs protection, or it is protected. So if someone thinks that they already have a similar design, they can challenge it at this stage where the publication stage. So after our this chair design, it passes the examination, then it get published. so that everyone knows that the chair design belongs to us. And if another designer they think that our chair looks too much like theirs, they can object and they can explain why it is looks similar. So that objection can be done at this stage. Last stage, that is registration. After our design is published and no one objects, then it gets registered. This means that our design is legally protected for 10 years. So no one can copy or use it without our permission. But after 10 years, we can renew the registration for another 5 years if you want to keep the protection. For example, if our the chair design it is registered, then we have the exclusive rights to use that design for 10 years. We can sell the chair and no one else can legally copy our unique design during those 10 years. After 10 years, we have to renew it. If we want another tenure of 5 years, we can renew it. Moving to the next question. Question is made, that is covering the classification of industrial design, design registration trends in India, international treaties, and a very important one, that is the case against Apple and Samsung. So again, I took the this question. Okay, so it's almost a sure question for the exam. Okay, so the answer scheme starts with the background. Apple company, we already know. Okay, I have an Apple with you, but this is not a company, it's just an Apple. It was there, huh? So I could have to show you. Okay, so Apple, it is a company, makes the electronics gadgets. Mainly we know Apple because we have iPhone. Many of us have iPhone with us now. So they have a unique way of designing their smartphones, and they protect these designs with patents. So a patent is a legal right which stops others from copying our invention or our design. So Apple claimed that another company called Samsung, which is also another big smartphone company, they copied the look of their phones without their permission. That became an issue. So the main issue in this case was whether Samsung's phone looked too similar to the Apple phone. Apple said Samsung copied their parts of their phone design, such as the rounded corners, the shape of the home button, and the layout of the icons. So the court had to decide the if Samsung phone design was close enough to Apple's that it would confuse customers or giving some advantages of the Apple's creativity to the Samsung. So the outcome, the court decision, that is the outcome. The court decided that Samsung did copy some of the important parts of Apple's smartphone design. Because of this, the Samsung had to pay the Apple company a very large amount of money as a penalty called the damages. So this case shows that the design matters. Companies can protect the way their product look, not just how they work. So it also shows that copying someone else's design can lead to serious legal consequences. So the significance of this case study, this case was very important because it set a legal precedent, meaning it became a reference for future cases. The ruling showed that the industrial designs, the way a product looks, are very valuable, especially in the technology industry where companies like Apple and Samsung they compete. Now more companies pay attention to design patterns to protect their products and avoid copying others. Next question: what are the key elements of protection provided to geographical indicators in India? Geographical indicators, it was not there in the previous syllabus, so it's very important one. So sure question will be there in the exam based on the geographical indicators. Okay, so moving on to the answer scheme. Exclusive rights. The exclusive rights, it means that okay, that only the producer from a particular geographic area, that is a particular land in the country or any place, the name is associated with that name of that place. For example, the Darjeeling tea. Darjeeling tea is only called Darjeeling tea because it is grown in the region of Darjeeling. So that land, whatever the nutritions that the plant tea plant gets, that gives the Darjeeling tea that special aroma or taste. Okay, so any other state or any other place, if they are selling Darjeeling tea, it should be the tea which is produced from Darjeeling with their permission, or they can have the right to sell. They cannot sell any other tea powder or any other tea product in the name of Darjeeling tea. So it becomes a geographical indicator. So next point, that is prevention of misuse. The unauthorized use of this geographical indication, that is GI, that geographic indication name, it is prohibited. So this means the people who are not from the geographical region, they cannot use the name to sell their product which is not grown or which is produced in that particular GI. So this rule helps protect the reputation and value of the original product. If someone outside of Darjeeling, they starts selling the tea and falsely labels it as Darjeeling tea, it is a violation of the law. So only tea from Darjeeling region can have that name. Collective ownership. Geographical indication names are owned by groups of producers from the region, not by any individual. So this allows all the authentic producers from that area to benefit from the use of the geographical name. For all the farmers who grow basmati rice in the specific region of India, they are sharing the right to use the name basmati. It is not owned by one single person, but it's a community of farmers from a particular area that you can search and find it out. Okay, task to you. Okay, duration. For like others, the GI also can last for 10 years initially. After that, it is renewed for more than 10 years period. It's my wife's phone. She keeps it near to me only. Okay. Okay, so example, if I say the Kanchipuram silk sarees, because my wife's name came suddenly, Kanchipuram silk saree name comes automatically. Don't laugh. Okay, so the Kanchipuram silk saree was registered. Why they registered, I don't know. Super quality sarees registered in 2010. It will be protected until 2020. And if the producers want to keep the protection, they have to renew for another 10 years. I think they already renewed it. So they have the rights. So that is geographical indicator. So continuing, one more question I framed on geographic indicator, because this is something new compared to the previous syllabus. So one more question is framed. What is the procedure for registering a geographical indicator in India, and what documents are required? It is answers are same, but again, GI word I wanted to use again. Okay, so answer scheme is it starts with application submission. So the group of producers or association, they must submit an application to the geographical indications registry. The continue. Okay, the supporting documents which are applicable or the application must include uh, it must include important documents like detailed description of the goods. So this explains what makes the product special and unique. Uh, what is that? Okay, proof of origin. Proof of origin which provides that the product is it is made in a specific geographical area. Then the map of the region which shows exactly where the product comes from, and the certified copy of registration document, even if it is applicable. Okay, so if a tea growers from Darjeeling, they apply for a GI, they need to include documents which describe the special taste and aroma of Darjeeling tea, prove that it is grown only in Darjeeling, and provide a map showing the exact area of production. Examination of application. Once the application is submitted, the GI registry carefully checks it. They examine whether the product meets the legal requirement to be registered as a GI. For example, the GI registry, it will look Coorg coffee application to make sure that it meets the criteria, such as being unique to the Coorg region, Madikeri Coorg region. The coffee is it's a GI. Okay, it should special qualities tied to that area. Publication in the official journal. Once the application is approved, the details of GI are published in the official journal. This is a public document which tells everyone about the new GI registration. For example, the Kanchipuram sari, silk sari, if you take, it was approved, and the detail about it was published in the official journal for to everyone to know. Now, the opposition period. Uh, Opposition period after it comes after the GI publication, when it is published, it is a set a period. I forgot how much exactly. Struggling with that. Okay, so there is a time period for this GI published to somebody if they want to oppose that period is. Once that period is done, it is registered. For example, if after all the check done and no objections are raised, the Coorg coffee producers will they got the certificate officially protect the name as Coorg coffee. So these steps are very important to make sure that the products which are genuine from a certain region, they can use their regional name. Only they can use their regional name. So it protects the heritage and the reputation of products like the basmati rice, Coorg coffee, Mysore sandalwood, Darjeeling tea. This by misuse from others. Okay, next question, that is IP organization and schemes of related to IP. Based on that question is framed. Question number 6. Okay, what are the some key intellectual property organization in India, and what schemes or programs do they offer to promote IP awareness and protection? Answer scheme. IP organizations in India. First one, that is CGPDATM, that is Controller General of Patents, Designs and Trademarks. This organization, it is responsible for managing the patents of inventions or designs, also called as product appearances, or trademarks, which are also called as the brand names, and geographical indications, that is GI, in India. If someone wants to register a patent for a new invention or trademark for their business name, they go through these offices. The second one, that is the National Intellectual Property Rights Policy. So this policy, it provides a framework for managing the intellectual property rights in India, across India. It ensures that all IP laws are well coordinated and that the rights of creators and inventors are protected. Then comes IPAB, Intellectual Property Appellate Board. So this body, they handle the dispute or the arguments and the request to review decisions, which are called the appeal, about the patents, trademarks and other IP issues. So if someone, they disagree with the decision which is made by the CGPDTM, they can take their case to the IPAB. Then comes a Patent Information System, PIS. This system provides information about patents which have been filed and registered. It helps the business or individuals search for existing patents to see if someone has already patented an idea similar to theirs. Then other schemes and programs which are related to IP. First one, that is SIP, Startup Intellectual Property Protection. This scheme, it is designed to help the startup, that is the new companies, to protect their inventions, protect their design as well as their trademark. So this provides it provides a financial support, and it speeds up the process of registering the IP rights. For example, if a new tech startup in our institution, students, is a start, it creates an innovative app, and they can apply for the support under the SIPP program, so that they will get help in quickly and affordably get a patent for their application. Then comes the IPA awareness program. These are the education programs organized by the intellectual property officers to spread the awareness about the IP rights and the importance. So this aim to educate the students, or to educate the business people and the public on how to protect their creative works or inventions. The National IPR Awareness Campaign. This is a large-scale initiative which teaches or educates different sectors like business or the universities and in the public on why the intellectual property rights are important and how they can protect their own innovations or creative work. Financial support for the IP filing. Government provides financial help such as the subsidiary, means the partial payment to small businesses or to the startups and the education institutions for filing the patents or their trademark or other IP rights. So this makes it very easy for the people with less money to protect their intellectual property. For example, areas a small rural business, they're making the hand woven scarves, may not have enough money to file a trademark for their unique brand. Though government financial support, they can file the trademark at a very reduced cost. So these organizations or these policies and even these programs, they work together in order to protect the inventors or the artists and business people, helping them safeguard their ideas and protect. So this ensures creativity and innovations are rewarded and are not stolen by the others. Hope it was interesting class on the module 5 of BRMK557 research methodology and IPR. Thank you very much for subscribing my YouTube channel. Thank you very much for sharing this video to others and giving the like button. Thank you once again. Have a nice day.